All right. Good morning, everybody. It is February 22nd, 2020. It is 9:11 a.m. and this is a regularly scheduled meeting of the Oil Conservation Commission. I am Adrienne Sandoval, Chair of the Oil Conservation Commission and Head of the Oil Conservation Division. Also with me today are the two other commissioners. Would you please introduce yourselves for the record?
Hi, sure. Good morning. Thank you, Madam Chair. My name is Greg Bloom, and I'm the designee of the Commissioner of Public Lands, Stephanie Garcia-Richard. Thanks.
Thank you, Madam Chair. Good morning, everyone. I am Dr. William Ampoma, a designee of the Energy Secretary and also a professor at New Mexico Tech. Thank you.
Thank you. Also with us today is Chris Moander, Counsel to the Commission, and Florine Davidson, Clerk to the Commission. First item on the agenda is approval of the agenda. The agenda will move forward as written. Is there a motion for approval of the agenda?
Madam Chair, I move to approve the agenda.
Second?
Madam Chair, I do second.
Mr. Moander, would you do roll call, please?
Yes, Madam Chair. Commissioner Ampoma.
Approved.
Commissioner Bloom.
Approve.
And Madam Chair.
Approve.
The motion carries.
Next item is approval of the January 13th and 14th 2020 Commission meeting minutes. Commissioners, is there a motion to approve those meeting minutes?
Madam Chair, I move to approve the meeting minutes from our January meeting.
Is there a second?
Madam Chair, I do second.
Mr. Moander, would you do a roll call, please?
Yes, Madam Chair. Commissioner Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
Thank you. All right, next item on the agenda is continuance of case number 21324. But before we jump into that, I just want to do a little housekeeping. So we still need to do deliberations and voting on 21324. And I'm expecting that's going to take a little bit of time. Following that, have agenda item number 5, which is Novo case number 21744. So that the lawyers aren't just sitting here, my recommendation would be for counsel in that case to check back in around 10:30. And we may still be deliberating or with going on agenda item number 4, but I think it'll take likely at least that much time, and we won't start on that case until at least 10:30 if we were to finish earlier. Does that work for counsel in case number 21744?
It does for me, Mr. Ernest Padilla.
Madam Chair, thank you. It should work as well.
Okay. All right. Well, oh, sorry, Mr. Reagan.
That's okay. I'm here too. I'm just going to be monitoring the case, but that works for me as well. Not a problem. I appreciate it.
Okay. Well, then you guys are welcome to either hop off and rejoin or just stick on and stay on mute. And I would check back in at 10:30, but we will not start case number 21744 until at least 10:30. All right. Let's jump back up to agenda item number 4, which was continuance of case number 21324 for submittal of closing statements and deliberations. The commission heard these cases on January 13th and part of the 14th. Council submitted written closing statements. that were timely delivered. Do you want to give, think, an opportunity to each of the parties to make brief statements? Starting with Ms. Shaheen, I'd say, you were given an opportunity to do the written, and so the majority of your closing statement should be in that. But if you have some brief closing statements you would like to make today, please go ahead, but be brief.
Thank you, Madam Chair. Sharon Shaheen on behalf of the applicant, Tom M. Ragsdale. And I will be brief. I'll just more or less walk through the headings of the closing statement. I understand that the commissioners were interested in being provided with the applicable law that would allow them to order the relief that has been requested. So I've done my best to do that in the closing statement. But briefly, Mewburn admits that they took the risk by drilling before they received the forced pooling order. Mr. Ragsdale never had an opportunity to elect to participate in the 1015-2H, which was the original the original well that was unsuccessfully drilled twice. On page 2 of the closing statement, I identified the statutes under which the commission has jurisdiction and authority to award the relief requested. That's specifically 70-2-6 and 70-2-11. And then section 70-2-17, which relates to compulsory pooling, limits costs to those in drilling the well, not another well, unless it falls within the regulation that specifies what can be considered a substitute well. I don't think it's disputed here that that the well that was drilled is not a substitute well under the regulation that applies here, which is 19.15.13.AB4. Moreover, it's Mr. Ragsdale's position that Mewburn failed to satisfy the notice requirements of 19.15.4.8 by failing to notify the division and failing to notify the non-operators that were being forced pooled that they intended not only to drill the 1510-2H instead of the 1015-2H, but that they were going to impose the cost of drilling the first well unsuccessfully on drilling the second well. This was never disclosed to anyone. And in fact, it appears to be Mewburn's method of operating, as their witness testified, that they don't provide information about drilling unless someone has already elected to participate. Finally, the rights and obligations of an interest owner under a forced pooling order are not dictated by the provisions of a JOA, and that's explained in the closing statement. Without production from the well that was first attempted to be drilled, that's the 1015-2H, Mewburn has no recourse because a co-tenant, which is what Mr. Ragsdale was at the time, must the operator of a well that's drilled as a co-tenant has no recourse for costs except from production from that well. There was no production from that well. So under the common law, Mr. Ragsdale has no obligation to pay those estimated costs that Mewburn was improperly demanding. If anyone has any questions, I'm happy to make an effort to answer them. Thank you.
Thank you. Thanks, Ms. Shaheen. Mr. Bruce, would you like to make a brief statement?
Yes, but very brief. I think it's set forth in Mewburn's written closing. I would just comment on Ms. Shaheen's statement, but this is how Mewburn operates. They're not giving out any information. There's a reason for that, and there's a reason why it's an industry custom that they don't give out well information before someone elects. It's because if you force pool someone and you make a well and they haven't elected yet, but you're forced to give them information, then they'll come in risk-free, and that's not the way the industry practices. Other than that, I would say that simply put, under the statutes and under the regulations, Mewburn contained everything in its applications which were called for. And the only other thing I would mention, there was a lot of discussion at the hearing about whether the junk toll costs were reasonable. Even Mr. Ragsdale did not say they were unreasonable. He just says it's for a separate well. But anyway, everything's set forth in the argument, and I'll close there. Thank you, Madam Chair.
Thank you. All right, I think at this point, the record of this application hearing is closed, or this hearing is closed. The commission, I think, will immediately deliberate so we can reach a final decision on the application. I move that the meeting be closed pursuant to administrative adjudicatory deliberations exception to the Open Meetings Act, Section 10-15-1H3, to deliberate in case number 21324. Is there a second to the motion?
Madam Chair, also second.
Madam Chair, would you like me to call a roll call?
Yes, please.
Commissioner Ampoma,
Approved.
Commissioner Bloom,
Approve.
and Madam Chair.
Approved.
Motion carries.
We will keep this meeting live and going, and Commissioner, so I'll stay logged onto this so everybody doesn't get kind of kicked out. And commissioners, we can hop on to the other platform.
So Madam Chair, do we log off of this one, myself and Commissioner Ampoma, and then join the other one and later come
If you
back to
want
this?
to, you can. Yeah, I'll stay logged in so this doesn't die. But you guys can log out if you'd like to.
Good, thank you. Be there shortly.
All right, we'll be back in a little while. Thanks, everyone.
I can't see Mr. Bruce, but perhaps.
Oh, good point. Mr. Bruce,
I'm
are you
here,
there?
Madam. I am here.
Great.
Thank you.
Okay, thank you. All right, it is 11:52. We are back. The commission meeting and the record is now open. The discussion during closed session was limited to agenda item number 4, which is the continuation of de novo case number 21324. On case number 21324, is there a motion containing, I guess I could state that better. I would make a motion on the following items. One, that there was a question on whether the notice was valid in this case. Per 1915-4-8, the requirements were met for the basic requirements of a notice. There is also the issue of then revocation of said notice, compulsory pooling, orders. Those there was proper notice requirements per 1915-4-8, and there was not enough evidence that was supported at the hearing that those orders were entered into unlawfully and therefore are not revoked. Next item was costs.
Madam Chair, before I forget, I was just reminded politely, we need a motion to reconvene into open session. One that'll discuss or point out that only matters subject to deliberations in this case were discussed.
I did say that only matters during that, but we need a motion to reopen.
Motion to reopen.
And then do I get to do the whole song and dance again?
Yes, you do, Madam Chair.
Great, that was a trial run. Okay, is there a motion to reopen session and only matters in case number 21324 were discussed during the closed session?
Madam Chair, I so move.
Second,
Madam Chair, I do second.
would you do a roll call vote?
Yes, Madam Chair. Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approve.
motion carries.
All right, fabulous. Well, I'm going to try and do this again and maybe I'll be better at it. We'll see. Okay. I make a motion on the following items that were disputed within case number 21324. First item was whether proper notice was given. Per 1915-4-8, Mewburn did meet the basic requirements of a notice and therefore proper notice was given to the applicant. Regarding revocation of the compulsory pooling orders, the notice requirements under 1915-4-8 were met, and there was not sufficient evidence presented at the hearing that the orders were entered into unlawfully, therefore the orders are not revoked. Regarding costs and whether they were appropriate, the costs were deemed appropriate. There was no evidence to refute the costs of the drilling and plugging of the 10H, 15, 2H, and 2HY wells. Therefore, the costs are appropriate. The compulsory pooling order and issues on basically whether or not Mewburn was allowed to move forward without having a valid compulsory pooling order through the 70-2-17C. Mewburn was able to move forward and drill the wells prior to having that order. However, if they move forward prior to having an order, Mewburn does that on its own risk. And so the costs were not, should not have been allocated further. On the next item, whether the 15, 10, 2H and 2HY wells constituted a substitute well. Under 1915-13-8 and 70-2-17C, particularly the 1915-13-8, only applies to sites with compulsory pooling orders. And because there was no compulsory pooling order at the time, that the 10, 15, 2H and 2HY wells were junked, or when the 1510 wells were staked, substitute wells are not allowed and do not apply because
Madam Chair, your audio broke up there. You kind of froze in your
did I freeze? Can you guys hear me?
sound better now. And Madam Chair, we heard you maybe halfway through your statement about substitute wells. Maybe you'd want to start
Okay.
over there.
Okay, for the substitute wells, I turned my video off, so hopefully it's better. Under 19, 15, 13, 8, that only applies to wells that have a compulsory pooling order. And because there was no valid compulsory pooling order at the time that the 10, 15 wells were junked, or when the 1510 well was initially staked, the provisions for allocating substitute well costs are not appropriate. Okay, so then on the participation of the applicant in the 1510 wells, it was found that the applicant received the elections letter and failed to make a timely reply. And the submission of a check is not adequate to show participation on its own. Wrapping all of that up, the costs of the 10, 15 junked wells should not have been allocated to the applicant. Is there a second on that very long motion?
Madam Chair, one last item, just to make sure the motion is complete. Referring to reopening of cases 20580 and 20809. Will the commission be reopening those cases?
No.
Okay. All right, I just wanted to make sure that got in there.
Thank you.
All right, Madam Chair, and I'll second your motion.
Thank you. Is there any discussion from the commissioners prior to voting on the motion?
None for me, Madam Chair. Thank you.
Yeah, Madam Chair, quick one. So with regards to the applicant participation, I thought we discussed that the applicant had the option to go to OCC.
Dr. Mpoma?
Yes, sir.
I would posit that more as a question and not discuss the deliberations on the record, please.
Thank you.
I think, I laid out where the commission landed on all of the kind of disparate items here, and ultimately sort of the final decision. So I think the majority of my discussion on this would have been stated within the motion. Mr. Moander, after the motion and the second, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Mpoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
All right. So I believe, Mr. Moander, are you drafting the order?
Yes, I was going to ask Madam Chair, I will draft the order.
Ms. McFarland, sorry, what were you saying?
I'm sorry. I think there's a little lapse in your sound because I got broken sound, and then suddenly you just said something to Mr. Moander, but I think I got it all. I got you saying, Mr. Moander, are you drafting the order? And Mr. Moander said, I am, Madam Chair. So did I get everything?
Yes.
Okay, thank you.
And we will vote on that final, or we will address that final order. What is the next? Is it the 10th?
I believe that's right, Madam Chair.
Okay.
And just to clarify,
All
Madam
right.
Chair, you would like that order available for entry at the next OCC meeting?
Yes.
Oh, all right, thank you.
All right. Well, with that, why don't we break for lunch? It's 12:05 right now. Come back at 1 o'clock and we will start with agenda item number 5, which is case number 21744.
Thank you, Madam Chair.
All right. Thanks, everyone. We'll be back in about an hour.
Thank you.
It's 1:02 on 222, and we will get started again after lunch. Coming in this afternoon, we finished up case number 21324, and we will start on case number 21744. The application of Cimarex Energy Company for de novo hearing of case number 21629. Mr. Savage, would you like to make a brief opening statement?
I would, Madam Chair. Thank you. Good morning, Madam Chair, Commissioners, Mr. Moander, and Council. In this evidentiary hearing, Cimarex respectfully submits that the evidence today will show that Colgate Energy and its affiliate Colgate Operating LLC did not satisfy its obligation of making attempts to reach a voluntary agreement with Cimarex Energy Company, both under the division's rules and the pooling statute. After Colgate sent out its well proposal on July 10th, 2020 in case 21629 pooling case, it had only one email exchange with Cimarex, an exchange initiated by Cimarex for which Colgate did not directly answer the question posed, nor did Colgate provide Cimarex with an agreement that it could review in any meaningful way. Under the OCD rules and policies, an application to a pooling procedure is required not only to send out the initial, an applicant to a pooling procedure is required not only to send out the initial well proposal, but is further required to show evidence of attempts to reach a voluntary agreement through a record of good faith negotiations. The evidence provided in this hearing will not only show that Colgate did not satisfy these requirements, but also made matters worse by making misrepresentations, or what Cimarex argues and believes are misrepresentations in the exhibits and testimony before the OCD. An applicable analogy to the purpose behind the OCD's rules and policies regarding the requirement for good faith negotiations is the concept of informed consent taken from the medical profession, for example. A form issued to a patient requesting agreement for a procedure is not valid unless the patient has provided information that informs the agreement. In the same way, the record of communications required by the OCD provides the following the well proposal ensures that a voluntary agreement has been sought and entered into. And if an owner does fail or refuse to enter into the agreement, then the record of negotiations ensures that the owner's decision was informed and therefore fully voluntary. For an owner with substantial interest, especially an amount of interest on par with the applicant, as is the case herein, good faith negotiations are essential to the process, which begins with the well proposal and continues through the chronology of contacts. Successful completion of this process is the only way to uphold the integrity of the proceedings, the rules of the OCD, and the statutory obligations under the Oil and Gas Act. Thank you.
Thank you, Mr. Savage. Mr. Padilla, do you want to make an opening statement?
Sure. Members of the commission, Madam Chair. This is a case where we have two experienced operators. In this case, it's true that there's one email between the parties. And you have to remember here that Cimarex was the target of a compulsory pooling application. In our pre-hearing statement, we said that the ball was in their court in terms of responding to the email and in responding to whether or not the well was going to be drilled in the north half of both sections 2 and 3 in 20 South, 29 East in Eddy County. When you're the target of a compulsory pooling application and you say that you're going to look for trade or potential resolution and you don't respond, then ultimately what's going to happen is that you have an application for compulsory pooling. The record is clear in this case that Cimarex totally mishandled the application or the application for compulsory pooling. It shows a pattern of negligence, is the only way I can see it. These wells are very expensive to drill. It's true that Cimarex had a substantial interest. They don't pay attention. In their one of the statements, I think by Mr. Morris, one of the landmen for Cimarex, he says that they had a number of team meetings and back and forth discussing proposals. Apparently this one was never discussed, and there's no excuse for that. The concept of good faith is a two-way street. I'm getting into a closing argument here, but the evidence is just going to show that Cimarex had a responsibility and had to respond to the proposal made by Colgate. So that's where we are, and in this case, it's very close. I will admit that in terms of what is good faith and what is not good faith, but you have to look at the parties. In this case, Cimarex is an experienced company. They know, they're supposed to know what they're doing, and they're supposed to respond to proposals, especially if you're the target of a compulsory pooling application. Thank you.
Thank you. Mr. Rankin, would you like to make any opening statements?
No, Madam Chair, I would not, other than just to make my formal entry of appearance on behalf of EOG Resources Incorporated. At this time, Madam Chair, and members of the Commission, EOG takes no position in this contest and is remaining neutral. Just has an interest in the outcome of the case, and so is appearing. Appreciate it.
Mr. Rankin, this is Chris Millender. I just have one question. If I could ask of you, did you file on behalf of your client a pre-hearing statement in this matter?
Do not.
Okay. I just wanted to make sure that was clear on the record. Thank you, Mr. Rankin.
Thank you. All right, Mr. Savage, would you like to call your first witness?
Madam Chair, thank you. I would like to see if we could quickly address some procedural matters before we proceed to the witnesses. I don't want to,
Okay.
I don't want to delay this, but would appreciate Mr. Molander's input on this. So as I understand this is a evidentiary hearing to address whether the pooling order issued to Colgate is valid or not, and that's based on whether or not Colgate met certain regulatory and statutory obligations. In my mind, it's the attempt to reach an agreement, good faith negotiations, and whether there are material misrepresentations or not. I noticed in Mr. Padilla's, one of Mr. Padilla's exhibits, he had highlighted some statements about missing notice, and also in his opening statement, he talked about a pattern of negligence, and that was the exhibit with the to reopen the case that Cimerex had filed. I would ask the commission to recognize that those issues are outside the scope of this particular hearing. There's no evidence that the missing notice represents a pattern of negligence. It's it was a unique set of circumstances, and furthermore, the commission has already ruled on that issue in the hearing motion, and I believe that they found that Cimerex did not have a valid excuse, but nonetheless, they also ruled that they qualified as a party of record and deserving of a de novo hearing nonetheless. So I believe those issues have been addressed already, and I believe that a request that we acknowledge the scope of this evidentiary hearing, and then in the pre-hearing statement that I submitted, I asked for a recognition of a rebuttable presumption in this case based on the rulings that the commission had made, a rebuttable presumption in favor of Cimerex.
So, Mr. Savage, can you maybe clarify what action you're seeking specifically from the commission?
Well, one particular action is that the arguments about any kind of negligence for missing notice is outside the scope of this evidentiary hearing, and they shouldn't be addressed in the hearing, or it should not be a valid subject of cross-examination in this. That would be one, and because that issue has already been decided, and we feel it only works to prejudice Cimerex to continue to bring that up when the focus of the evidentiary hearing is otherwise. So that would be one request. And then the other request is if the commission feels in its wisdom to do so, that the rebuttable presumption that we describe in the procedural matters of the pre-hearing statement be acknowledged. And that was Cimerex pointing out that the commission, the commission pointing out that it found Cimerex's arguments compelling, that there were misrepresentations that undermined the judicial proceedings and the integrity of the judicial proceedings, and therefore they found it compelling. Now, they did not go as far as to rule on whether they actually occurred, and I believe that that's why we're having this evidentiary hearing. But the fact that they found it compelling suggests to us, under the Black Laws Dictionary, as they found it to be convincing, and therefore we believe that a rebuttable presumption has arisen in this case.
Thank you, Mr. Savage. Madam Chair, would you like my input on this, or do you have some thoughts?
I have some thoughts, but I would like your input.
Okay, so at this point, I think my suggestion is the best way to proceed is that there may be exhibits, as Mr. Savage has referred to, that potentially, at a minimum, could be objectionable. Whether or not the commission chooses to accept those documents and any attendant arguments, I think might be best reserved for consideration at that time if there's an objection or an issue, because part of this hearing is to collect evidence and have the commission weigh it. And there is a presumption that the commission will take in as much evidence as it needs to make its decision. As to the rebuttable presumption, it probably would have been helpful to have something like that. Well, both of these issues, so one of them with the evidence being a motion, they're subject to a motion in limine, perhaps to exclude. And then the other one, moving the commission to accept and implement the rebuttable presumption. That might have been subject to motion practice, but I think in this instance, the commission knows what it's ruled upon and it understands its own rulings. So I think you could probably hold both decisions in abeyance to see how the evidence fleshes out. But ultimately, I would advise the commission to, when it renders its final decision, to address the rebuttable presumption request by Mr. Savage.
Makes sense to me.
Thank you, Madam Chair.
So, Madam
Okay.
Chair, is that a ruling that you're going to
Yes.
hold decisions on in abeyance on
I'm
these?
sorry. Yes,
Thank you, Madam Chair.
I could have been
Yeah,
clearer.
I may add, Madam Chairman, the this motion or procedural question that Mr. Savage raises goes to the weight of the evidence. I think the commission has to weigh everything. That's really, in an administrative hearing, we're not bound by strict evidentiary rules as you would in a judicial matter. That's all I have to say on that.
Thanks, Mr. Padilla. Okay, with that, Mr. Savage, are you ready to call your first witness?
I am. Thank you. That's Mr. John Kaufman, landman with Cimarex Energy Company. Exhibit A in our pre-hearing statement gives an overview of his testimony, but I would like to ask just a few additional questions for some clarification and to address some points. The Colgate did not provide written testimony as an exhibit, so they've had the benefit of reviewing our testimony, and I'd just like to clarify a few items. Mr. Kaufman, are you present?
Yes, I am.
Okay.
Mrs. Mary, did you, over there, I see him now. I wondered where he was. This is the court reporter, Mary McFarland. Sir, would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Mr. Kaufman, your qualifications as a landman and your work history with Cimarex is listed in your written testimony. Is that true?
Yes.
Okay. And based on your testimony that you submitted, Cimarex was the party that reached out to Colgate about the well proposal, not Colgate. Is that correct?
Yeah, that's correct.
Question that you posed in your email. Colgate stated in its pre-hearing statement that you dropped the ball by not responding to Colgate. Do you believe that Colgate had the obligation to reach out to answer the question? If so, why?
Yeah, I did. I think if I remember correctly, Colgate has a 27% working interest and we have a 25%. And it's kind of industry standard to reach out to the larger working interest owners, especially when they're of equal, I guess, share of the well. At least a few times, if you haven't heard back from them, to engage in good faith negotiations.
And Mr. Haddick, he is the landman for Colgate. You had the one email exchange with. Is that correct?
Correct.
And how do you feel like he responded to your question posed?
I don't think he answered my initial question. It was kind of an open-ended response on throwing ideas around at some point in the future.
Okay. And this is shown by the sole email exchange you had with Colgate, as reflected in Cimarex's Exhibit C. Is that correct?
Correct.
And in your experience as a landman dealing with operators and pooling applicants, would you have expected Colgate to have provided additional information based on this exchange?
Yeah, I think it's also industry standard to send an operating agreement, or at the very least, you know, a contract area to know, A, what our working interest would be in the unit and what that unit would outline. I know we do for our proposals, so it's pretty common practice.
And that practice that you have, that you use for your proposals, are those based on anything? For example, are those based on guidance from the OCD or any regulatory guidance?
Yeah, I do believe that's part of some OCD statutes. I couldn't quote them, but I think it has to be an OA has to be sent with the proposal for it to be, I guess, quote, a valid proposal in my mind.
And did Cimarex fail or refuse to enter an agreement with Colgate?
No, we weren't given the opportunity to.
Okay. But what about the well proposal? Wasn't that an opportunity to enter into an agreement?
No, like I said, I don't think that one single well proposal was sufficient to enter into an agreement without more information.
And Mr. Kaufman, under the good faith practices based on your experience as a landman, what is the minimum communication you would have expected from Colgate if they had reached out?
At least another follow-up to see if, A, we had any, you know, ideas of trades, anything like that, but, you know, at least a courtesy follow-up before pooling.
And they did not make any attempts in that regard?
No, they did not.
And have you reviewed the assertions in Colgate's application and testimony at the hearing and Colgate's communication timeline? That would be Cimarex exhibits F, G, and H.
Yes.
And how would you describe Colgate's statements and assertions regarding their attempts to communicate and reach an agreement with Cimarex?
I would say that the communication was lacking compared to the statement.
Madam Chair, at this time, I ask the Commission to accept Exhibits A, Mr. Kaufman's self-affirmed statement, into the record along with Exhibits C, F, and H. And I make Mr. Kaufman available for further questioning.
Just to confirm, you said Exhibit A, C, F, and H?
That's correct. Exhibit A, Exhibit C, and Exhibit F, and Exhibit H.
Okay. Any objections, Mr. Padilla or Rankin?
No, Your Honor, or no, Madam Chair.
I'll take that. Okay. Commissioners, any questions before we enter those into the record?
No, Madam Chair.
No, Madam Chair.
Okay, Cimarex exhibits A, C, F, and H are entered into the record. Go ahead, Mr. Savage.
Oh, Mr. Kaufman is available for questioning by Colgate.
Okay, Mr. Padilla. Oh, go ahead.
I would assume that would be the proper procedure at this point, instead of going forward with my next witness.
Yes, if you're done with questions. All right, Mr. Padilla, do you have questions for Mr. Kaufman?
Yes, I do. Mr. Kaufman, how long have you worked for Cimarex?
Coming up on 4 years.
At the time of this proposal, how long had you worked there?
Probably around 2 years.
How do you handle compulsory pooling? Or let me ask first, proposals well proposals made by other operators?
Could you repeat the question? It kind
How
of cut
do
out.
you handle well proposals made to Cimarex by other operators?
We send them out to our team and have them on a OBO list.
In your self-affirmed statement, you say that you had team meetings regarding proposals and regarding well applications and development plans. How many, what did you do with this particular application in terms of your team meetings?
I couldn't speak to a specific time, but we go over upwards of 30 proposals at a time with our team.
I'm asking about this particular proposal. What did you do with it?
In what meeting?
Well, after you received the proposal from Colgate, what did you do with this application in terms of discussing it with your team?
We put it on our spreadsheet, like I said, and then discuss it. We have a hierarchy of what comes up as a fire drill versus not a fire drill.
Did you have a priority for evaluating any proposals as they come up?
Could you repeat the question?
Well, let me rephrase. Do you prioritize proposals as they come into your office?
Yes.
And what ranking did you give this particular proposal?
Since it wasn't under an existing operating agreement, it would not be the first on our list.
Okay, you would look at the proposals that already were subject to a JOA, correct?
Correct, with a 30-day
So
election.
you didn't put this at the top of the list.
No, we did not have a time clock under an operating agreement for this well proposal.
Now, it's fair to say that the ball was in your court to get back to Cimarex concerning your well configurations and the question you asked in your email, correct?
Could you rephrase the question?
What I'm saying is, wasn't the ball in your court to make a response based upon what you said in your email to Mr. Hedrick?
I didn't feel like my question was answered in Mr. Haddock's response.
Well, he did answer that the north half of both sections 2 and 3 was what their unit proposal, right?
I think he mentioned that was where the well was going to be drilled, which I do agree with, but that doesn't necessarily mean it would be the contract area.
But you also talked about a potential trade, correct?
I'd have to review.
Well, in preparation for this hearing, did you look at your email, your exhibit?
I don't think I mentioned a trade in my email.
Well, you said you were going to look at your acreage, didn't you, or something to that effect?
I do not believe so.
That would include the south half, north half.
I do not believe I mentioned a trade.
But you're saying just trying to get a feel for what your plants are in the area, and you didn't ask any questions to speak of, right?
I think I asked if it would be a north half JOA.
Did you ask for Mr. Hadjic to send you the JOA?
I asked what the JOA would cover.
In your well proposals, do you always send a JOA?
Yes, we do.
Other operators sometimes send one and sometimes they don't, correct?
Majority do.
How do you know that?
Because I received them. The majority that I received it.
How many, at the time of this thing, how many well proposals had you worked on for Cimarex?
I couldn't even give you a good number. 4 or 5 dozen.
How many of those proposals ended up in a compulsory pooling application hearing?
I'm not sure.
Tell us about how many wells Cimarex operates in southeast New Mexico.
What about them? How many?
Yeah, yes.
I don't think I could give an accurate number. What constitutes southeast New Mexico?
Madam Chair, I'm going to object to that question. It's a broad general question, and I'm not sure where this is going. It seems to be outside the scope of direct.
I guess it seems like a rather simplistic question. Either he can answer it or he can't.
I don't know the exact number.
Well, let me put it this way. Cimarex has a whole bunch of wells out there, don't they? They drill a lot of wells. You'd agree with that, right?
Correct.
And you would say that Cimarex is a proven operator, right?
I would.
They're a successful operator as well, right?
Yes.
You say that one more email from Mr. Hadget would have satisfied the good faith requirement that you are that Cimarex is bringing up today.
Say at the very least one more follow-up email before pooling. Yes.
So you're saying that 2 emails would have satisfied that rather than just one?
I'm not sure how many emails it would take. I guess it depends on the substance of the emails.
So you have a compulsory pooling application in your court here, and is there any diligence on your part to make sure that you don't get force pooled?
Yes.
And what was your diligence in this case?
In this case, when I took over this specific proposal, it was moved to Riley Morris. So I don't know what past the time it was in my, I guess, quote unquote box. Other than that, we get a lot of proposals that are trade inviting that aren't ever going to necessarily get pooled or drilled for that matter. This came across as one of those proposals.
So what do you do when you get a notice of application for hearing?
I did not receive that notice in this case.
But Cimarex did get it, right?
Not when I was working this.
Madam Chair, I might object to this. This is something that we discussed at the beginning regarding procedural matters. This has already been reviewed by the commission and decided upon, and we know what the outcome of that is.
May I respond, Madam Chair?
Go ahead.
Same thing, it goes to the weight of the evidence. Good faith is a very broad issue in this case. We're talking about practice and custom in the oil industry. They're the ones who brought up lack of good faith, and I'm just trying to figure out how this would have how it fell through the cracks.
Madam Chair, the focus of good faith in this evidentiary hearing is good faith negotiations, whether Colgate engaged in them or not. Whether or not Cimarex accidentally misplaced a notice is not a question of good faith. It's an accident. There was no intent involved. In the case of negotiations, there is a very prominent question of intent. And the commission has already decided on the notice issue.
I mean, the commission decided to hear the case to see whether or not there is enough evidence to from that those original orders should not have been issued because they didn't meet the requirements. Think I'm inclined here to allow this line of questioning. I think we need all of the information in order to make an informed informed decision. Mr. Moander, do you have any additional input?
Yes. So Mr. Savage, he is correct. There've been some rulings that touch on some of these issues. I think the commission is apprised of its own ruling, and it is to the benefit of the commission to see where the evidence goes. Of course, Madam Chair, if you hit a point where you feel like this matter has been thoroughly covered, you can, of course, direct the parties to move on. This is also, I should point out to the commission, the first time the commission's had an opportunity to really have the lawyers dig into the material with witnesses. Everything else has been largely paper at this point. So there is some value in hearing what, the individuals who submitted affidavits, whose statements have been used by parties, to have those statements tested and evaluated.
Yeah, and we haven't had the opportunity to question witnesses. Previously, they were just status conferences. So I think in that case, Mr. Padilla, you can continue with your line of questioning. And the objection from Mr. Savage is overruled? Sustained? Which one?
That would be overruled, Madam Chair.
Overruled. All right, great. Thank you.
Okay.
Go ahead.
Mr. Kaufman, I'm not sure where I was, but I think I was asking you about how the notice of the hearing fell through the cracks and what your knowledge of that is.
So at the time of, I guess, I'm not sure what time that notice was sent, but I was moved off of this project into Lee County specifically. So at the time of the notice, I was not working this proposal.
Was Mr. Morris, took over for you?
Correct.
And you were working under Mr. Morris all along?
No.
Okay. I don't think I have any further questions. Thank you, Mr. Kaufman.
Mr. Rankin, do you have any questions?
No questions.
Commissioners, do you have any questions for Mr. Kaufman?
No, Madam Chair, I do not.
Madam Chair, I do have a quick one from Mr. Kaufman. Okay, thank you. So I do have a quick one. So when Samarax received the proposal, the well proposal from Colgate, I want to know what decision was made to this actual proposal when you guys when your team met. What was the decision that you made on this particular proposal?
We did not have enough information to make a decision. So in the proposal sent by Colgate, we were required or asked to send an election before an operating agreement was sent back to us, which is not usually how that works. We don't like to commit capital to a project before we know the terms of the operating agreement and other contracts that might happen. So when we received the proposal, there was not enough information for us to make a decision either way as a team.
So in that case, did you follow that with Matt to make sure that your question was answered, to your satisfaction? Because I think good faith goes in both ways, right? So did you guys do that?
So after I received the proposal, realized there wasn't enough information, then I reached out to Mark. Yes, that's correct. And Mark responded back with his response that did not, in my mind, answer my question.
Yeah, but did you make a follow-up to make sure that your question was addressed?
After that, via email, no.
You said via email, no, but was there any other medium?
No.
Okay, thank you. Thank you, Madam Chair.
Thanks. Just to confirm, so Exhibit C, which is that email exchange from August, that was it. There was no additional follow-up.
Are you asking me?
Yes.
Yes, that's correct.
Okay.
On my part, at least.
Sorry, I didn't hear that. Did the witness say something else after yes?
Yeah, there was no follow-up on my part, at least.
Thank you.
So even though Mr. Hadik said he would be happy to talk some options for the offsetting acreage in order to fully maximize the development of the area, you never followed up with a phone call or to this email?
Correct.
Okay. Thank you. Mr. Savage, do you have
Madam
any?
Chair?
Go ahead.
Yeah, may I ask a question of Mr. Kaufman? Mr. Kaufman, I was looking at some of the previous record here, and one of the things that was cited was 1915 412A, which relates to compulsory pooling applications, and these call for, quote, evidence of attempts the applicant made to gain voluntary agreement, including but not limited to copies of relevant correspondence. Correct me if I'm wrong, but in this case, we just have the one attempt. It was a single email. Mr. Pajdik at Colgate, is that correct?
Correct.
Okay, no further questions. Thank you.
Mr. Savage, do you have any follow-up questions?
I do, Madam Chair. Thank you. I'd like to continue that line of thought that the Commissioner brought up. Mr. Kaufman, you're familiar with the exhibit, the chronology of contacts that an applicant is required to list all the contacts of reaching out to the owners and showing a chronology and history of interactions.
Correct.
And would you agree that the reason for that exhibit corresponds directly to the rule that the commissioner brought up, 1915-412, in which the applicant is required to show evidence of attempts made to gain a voluntary agreement.
Yes.
And under that plain language, who has the burden and the obligation to make attempts? The applicant or an owner?
Applicant.
And how many well proposals do you receive? Numerous? Would you receive numerous well proposals? Can you give an idea of the volume that you receive?
Quite a few.
And you have a full system, in-house system that's very detailed, in which you place these proposals in. You tag them with information, and then you monitor them. Is that correct?
That's correct.
And is that monitoring based in large part on the obligation of the applicant to provide to make affirmative attempts under the rules of the OCD?
Correct. We can tell how pertinent and how likely a well proposal is, I guess a project is going to be drilled based on the amount of correspondence we receive from that operator.
Okay. So an operator who sends out a well proposal and then follows up pursuant to the obligations under the rules and the statute, they send you affirmatively send you a JOA or operating agreement to try to satisfy the rules of gaining a voluntary agreement. Those would be registered in your system as a higher priority than somebody who sends out a well proposal. You try to reach out, they give one response. It seems to be off the mark of actually addressing the question of the JOA that you raised, and they speak in generalities, and then you hear nothing from them again. Would that be the reason why a well proposal such as that would take a lower priority?
Yes.
Based on the actions, the behavior of the operator.
Absolutely.
Where it looks like it's not going to go to hearing.
Yes.
Since we're allowed for some line of questioning regarding notice, is it true that the notice was sent and received on Christmas Eve?
Yes. Yes.
And was that not in the throes of the lockdown and chaos of going on in companies dealing with the COVID emergency?
Yes.
And if I remember right, all the employees of your team were having to work at home. Is that correct? Under
I'm gonna object at this point. Mr. Savage is the one testifying here, asking leading questions. And I think he ought to have his witness answer questions that are not leading.
I tend to agree. Mr. Savage, can you reframe the questions, please?
Yes, thank you, Madam Chair. I would withdraw those questions. Can you describe the conditions, Mr. Kaufman, under which you received but misplaced or Cimerex received but misplaced by accident the notice that Colgate sent?
We did receive them on Christmas Eve, and during Christmas Eve, obviously, a lot of people take vacation time, and during that time as well, we were working from home per Cimerex safety guidelines due to the pandemic.
And yes, and Madam Chair, I know that the commission ruled on this question, but the circumstances are certainly informative of the situation, we believe. Mr. Padilla brought up the fact of the question about whether one additional email would have satisfied the criteria for good faith negotiations, and you responded that it would depend on the content and the substance of that email. Is that correct?
Yes.
So do you agree that, I mean, there could be any number of emails that were exchanged, but if the substance of the content is not in good faith or misses the mark, that would not necessarily satisfy the criteria.
Correct.
And certainly in the instances of these two emails, there is nothing, would you agree that there's nothing of, how would you describe it, those two emails in terms of seeking an agreement or substance of a discussing an agreement of all?
I would not say there was any content of coming to an agreement within those two emails.
Coming to agreement and then you just trailed away. I would not say there was any content of coming to an agreement, whatever came out.
Within those two emails, no.
Okay. I have no further questions. Thank you.
Thank you, Mr. Savage. Do you have an additional witness you would like to call?
I do.
I would say that I don't think we are formally dismissing Mr. Kaufman. We may have further questions later.
Thank you. Oh, let me, yes, okay. Mr. Raleigh Morris, I'd like to call Mr. Raleigh Morris for some questions regarding direct on the same topics.
Mr. Morris, I just made you a panelist, so you should be able to, ooh, there's feedback. Try talking.
Hello?
Ooh.
Can you hear me now?
Madam Chair, do you want to hand over administrative powers to me and log in?
Yeah, I'm sorry, I got double voices on everything there that Mr. Myander said, so I don't really know what he said. Something about log in.
Mr. Right, let's see, Morris, are you also called in somewhere?
No, I'm not.
Is there someone near you? That's called?
No, ma'am.
Mr. Morris's sound is fine. On this end.
On this end.
We weren't having these duplicative problems.
Maybe we should have everyone re-log in. I mean, I hate to do it, but
You weren't double there. Something must have happened. Somebody hit something. Could you say something, Mr. Myander?
something.
I got one something. That's good. That's an improvement.
It seems to be when Mr. Morris is unmuted, we get the double. When he's not unmuted. When you're muted, it's okay. When you're unmuted, we get like two of everybody. We can make sure everybody's muted when you're speaking, and then you need to mute right after you're done speaking. We can try that. Do you want to?
Okay, how about now?
We just all need to make sure to be muted. And I think Mr. Morris, every time like you're done speaking, and unmute.
Is he only on his computer microphone? He's not got another microphone lying around somewhere that might be on?
could also have him leave the meeting and come back in to see if that fixes it.
Oh, I was muted and I was speaking and nobody's listening to me. Because I'm not there. I think he's logging out and logging back in. We'll try that. Okay, Mr. Morris, let's.
Any better?
Unfortunately, I don't think so, Mr. Morris.
Actually, it's okay. We're not getting the feedback. Well, you're muted right now. Unmute. Unmute.
I mean, could it be you need to turn my cell phone off? I would think everyone else in there has cell phones.
He definitely needs to turn. He's joined through the computer, right?
Yeah,
So
I
he
don't
definitely
see him.
needs to turn his cell phone off because that does set them off sometimes. Not
Maybe it's
always, but sometimes.
How about now?
Um, no. Okay, we're just gonna have to be really good with muting and unmuting and just take it a little bit slower on questions, etc. So, Mr. Morris, just stay muted until after Mr. Savage or the commissioners or whoever ask you the question. And then whoever's asking the question, I need you to please mute yourself right after you ask the question and just like take a breath. Okay. Mr. Savage.
Would you like me to swear the witness in, or?
Oh yes, that would be great. Thank you.
Mr. Morris, would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Mr. Morris, good afternoon. You are the primary landman on the land team that dealt with this particular application with Colgate. Is that correct?
Yes, sir. Once it was applied for.
And you have testified before the OCD. You have been involved in numerous pooling applications. You have been on both sides of the fence in pooling applications over the years. Can you just kind of describe a little bit about your experience?
Yes, sir. I've worked for Cimarex, now Coterra, for approximately 3.5 years. I've been a landman for almost 12, and worked in New Mexico for the last 3.5 years for Cimarex. In that time, I've worked North Lee County, North Eddy County, and now I work all of Eddy County.
In this particular case, you had a very high volume of workload. You brought in Mr. Kaufman to assist. Is that correct?
Yes, sir, that is correct.
And then at some point, it sounds like, based on Mr. Kaufman's testimony, that the case transferred back to you.
Yes, sir, that's correct. I couldn't give you an approximate time that it did. But by the time that we received notice of application, it was, within my camp. Yes, sir.
And you provided your testimony in Cimarex's Exhibit B. Is this testimony true and accurate to the best of your understanding and knowledge?
Yes, sir.
You self-affirm, and have you reviewed the self-affirmed statement of Mr. Kaufman in Exhibit A?
Yes.
And based on your discussions with Mr. Kaufman during the time leading up to the filing of Colgate's application and having the hearing, do you find this testimony to be fully accurate and true to the best of your knowledge?
Yes.
And have you reviewed the assertions in Colgate's application and testimony at the hearing and Colgate's communication timeline that we have presented as Exhibits F, G, and H?
Yes, I have.
And how would you describe Colgate's statements and assertions regarding their attempts to communicate and reach an agreement with Cimarex?
It kind of went out there at the first. Could you repeat that, please?
Yes. And how would you describe Colgate's statements and assertions regarding their attempts to communicate and reach an agreement with Cimarex?
I would say that they're not indicative of the conversations that I've had with John Kaufman on this matter, or the post dealings with Colgate after application. And I don't feel that Colgate ever entered into any good faith negotiations to where we could, come to a voluntary agreement, whether that be through J-Way or trade.
And as has been mentioned previously, good faith negotiations are a two-way street. But you have done numerous poolings with the OCD, and you're familiar with the rules. Is that correct?
Yes, sir.
And this particular rule that has been brought up and referenced, 1915-412A, in which the applicant must provide evidence of attempts made to gain voluntary agreement, including but not limited to copies of relevant correspondence. Is it your understanding, based on your experience as a landman and doing the exhibits, such as the chronology of contacts, that the burden is on the applicant to gain a voluntary agreement?
Yes, sir. That's how we operate at Cimarex.
And is that, in your experience, is that how other prominent operators operate as well?
Yes, sir. We feel like we have a pretty open line of communication with the vast majority of operators that we overlap with, and we are instructive as to our plans coming forward over the next calendar year and what type of wells we're planning to drill and how we're planning to get them drilled, whether it be through a voluntary agreement or pool.
And you can confirm that every well proposal you send out a copy of the operating agreement. So there's no question.
Yes, sir. That's our standard operating procedure.
I'm curious, Mr. Morris, did you meet with Mr. Haddock on other matters or projects after the Meridian well proposal, but before the filing of Colgate's application and the hearing during that?
Yes, sir. We were working on a trade for some small non-op interests that we owned within, I think, 3 or 4 of their proposals for some of their non-op interests in one of our proposals.
So you had one-on-one contact during those times?
Yes, sir.
And can you give an estimate of how many times you did meet and when during that time period? during that time period?
It was primarily through email and over the phone. We never met in person. I think we met in person once to trade the trade documents and instruments. But I would estimate somewhere, over that time period, maybe 3 or 4 dozen exchanges of email.
And this would have been during a time after Mr. Hadik has decided to go forward with the pooling in the Meridian case.
I think that the pooling was sent out in middle December. I think we closed our trade the end of November, if I'm recalling that correctly. But there was a little bit of overlap there, if I can recall that correctly.
So are you familiar with Exhibit H? That's our Exhibit H. That's the communication timeline.
Yes, sir.
That Colgate provided. Do you have that access to that?
Yes, sir.
At the top of the entry, is there a entry where
Sorry, I'm sorry, I can't make that out.
I'm sorry, I can't make that.
I'm sorry.
Mr. Savage, I'm
Yes.
manually muting and unmuting you.
Okay.
What would be helpful is if you can, between each one of your questions, instead of staying unmuted, mute when Mr. Morris is answering. So ask your question, mute, Mr. Morris unmutes, answers the question, and then you unmute, then you ask your question. I know it's a pain,
Oh,
but
that's fine. I understand.
but that's, I think, what we have to do at the moment.
I agree. Okay, Mr. Morris, the first entry of Colgate says October and November 2020. It looks like, do you agree that that's when Colgate began negotiations for the purposes of pooling the Meridian well?
I'm seeing the October, November 2020. That is in regards to Concho. Yeah. I would assume that there was somewhere around that time period that they started entering into negotiations for other parties. I think Concho has quite a bit of an interest between them and ConocoPhillips. I think it's about 23%, if I'm not mistaken.
So if Mr. Hadik was aware he was going forward with the pooling of the Meridian well, and he met with you several times before filing the application and the hearing, he would have opportunity to have negotiated or reached a voluntary agreement. Is that correct?
Yes, sir, that is correct. And to my knowledge, there was never any discussion of the Meridian wells. Because we were working on getting the previous trade closed, we didn't start another one from scratch.
Thank you, Mr. Morris. At this time, Madam Chair, I ask the commission to accept Exhibit B. That would be Mr. Morris's self-affirmed statement into the record. And I tender Mr. Morris as a witness available for further questioning.
Thank you. Mr. Padilla or Rankin, do you have any concerns with entering Exhibit B? Mr. Padilla, Mr. Rankin? Maybe you're both muted.
No, Colgate does not have an objection. Can you hear now?
Yes.
Good.
Mr. Rankin? I'm going to take that as not having an objection. Commissioners, any objections to entering in Exhibit B?
Chair, no.
No, Madam Chair.
Okay. Cimarex Exhibit B is now entered into the record. And Mr. Savage, you're done with your initial questions of the witness, correct? You're muted.
That is correct, Madam Chair. Thank you.
Thank you. Mr. Padilla, would you like to question the witness? Please keep in mind you need to mute and unmute each time you answer a question. Don't just leave it unmuted, please.
Mr. Morris, I'm looking at paragraph 4 of your self-affirmed statement, which is Exhibit B. It states, after the dates of Mr. Hoffman's email exchange, I had meetings and discussion with Mr. Kaufman regarding the status of our interests with Colgate as required by our land team. And I reviewed copies of his email exchange with Colgate. How many meetings did you have concerning this particular proposal? I'm not.
Team meetings or
I'm not-
meetings specifically with Mr. Kaufman?
I'm not, well, you said you had meetings and discussions with Mr. Kaufman in yours.
I would say that less than 5 would be an accurate statement.
And what was the consensus of your discussions?
That it was most likely not a serious proposal because it didn't contain JOA, didn't define the contract area, and there was no real follow-up to the emails that they had exchanged.
Did you tell Mr. Kaufman to get more information?
No, sir, I don't believe I did.
The next sentence in your paragraph 4 says, landmen are required to inform the team of any communications they receive regarding our interests in poolings which affect our interests. Let me ask this, since you had a well, you didn't have a compulsory pooling application on the table, but generally, if you're the target of a proposal, isn't it incumbent on you to follow up, asking more questions about the proposal, given your stature in the industry?
I would say it falls solely on the operator because they're the one proposing the operation. And to define that more clearly, I thought that the email from Mr. Kaufman to Mr. Haddock was an attempt to do that, and that attempt went nowhere.
You read that email, wasn't the ball in Mr. Kaufman's court?
No, sir, I do not believe it was, because Mr. Haddock had thrown out that there would be things to talk about within the area. I think that put the onus on Mr. Haddock to follow that up with any type of trade proposal or something of that nature.
Were you dealing with Colgate and other trades at the time?
Yes, sir, I was.
And you never brought up this particular proposal?
No, sir, we were in the process of getting an 80 acre for 80 acre proposal closed that had taken quite some time because we were working on keeping some non-op interest in one of the proposals. And like I said, it's incumbent on the operator or applicant to bring up any trade proposals on a case that they are considering to pool. There was not a JOA provided, so I did not think it was a serious proposal.
So what did you have to trade? You later on did trade acreage, did you not?
No, sir, we never made a trade.
Was there a problem with the titles in your trade proposals that you had?
Yes, sir, there
I'm
was a
sorry,
portion of
I
the
didn't
acreage
get the
that was.
last part of that. Was there a problem with your titles in the trade, whatever?
Proposal.
Yes, sir. We had some of our acreage defect out.
And that's why you couldn't settle this case, right?
Yes, sir. We tried multiple other trade iterations and we couldn't come to a resolution.
So going on to your paragraph 5, you mentioned in there that you have known a landman for Cimarex, or that you are a landman for Cimarex involved in well projects. And Colgate knows your contact information. But isn't it a fact that you were communicating anyway on this other trades?
Yes, sir. That's correct.
So going back to the priority for this particular proposal that Mr. Kaufman testified about, you valued this proposal pretty low. Do you agree with that, his testimony?
Yes, sir.
So does
I
that
think
mean
that the reasons that we valued it low are the mitigating reasons that I've already mentioned, being that there was not a JOA proposed nor a contract area, and there wasn't any follow-up to the questions posed.
wasn't the well proposal, didn't the well proposal define the AFE define the acres that would be committed to the well proposal?
Yes, committed to that proration unit, but not what's committed to the contract area, and those are two totally different things. Because once you commit your interest to a contract area, then you're on the hook for future capital spend, and that wasn't detailed in the proposal.
The only proposal that was made by the well proposal made by Colgate was drilling wells in the north half of sections 2 and 3, correct?
Yes, sir, that is correct. And there was no further information about the contract area, not just the proration unit.
Well, isn't it a two-way policy here? I mean, as I understand your testimony, you're saying that the burden was on Colgate to do everything, and you had no obligation to communicate back. Is that what you're saying?
No, sir, I'm saying that there's an obligation from the proposing party to clearly define their proposal. And within that is what area is going to be included within their overall proposal. If it's only going to be the north half, then proposing that that's the contract area, this is your working interest, NRI, that would be a different level of proposal in our mind if we would have gotten a copy of the operating agreement and it was clearly defined.
Did you ask define the contract area for Colgate?
I was not the original landman receiving the proposal.
At any time, did you define the contract area after you took over the project?
Well, at that point, we'd already been pulled. So this is back in early January. There was no point looking at what would be a proposed contract area when we had a competing proposal across portions of that contract area.
Okay, so we're talking about two different things here, correct? Contract area and the spacing unit.
Yes, sir.
So you never got back to Colgate about the contract area that you wanted to develop and grill, right?
Yes, we did. We sent competing proposals along with the JOA, encompassing a portion of the proposed Meridian well.
Wasn't that after you were already force filled?
That was after application had been made and had been heard before the commission, yes.
Now, to your knowledge, was there any suspension of rules about compulsory pooling or timeliness in terms of COVID as it relates to the Oil Conservation Division?
I'm not really understand the question.
Well,
rephrase that.
because of COVID, did the Oil Conservation Division suspend rules about timing of compulsory pooling hearings?
I'm sure they went, some of the rules were that they would have to go remotely, but I'm not sure of the timelines if they were changed. No, sir, I'm not.
Mr. Kaufman testified that Cimarex received a notice of hearing on Christmas Eve. But that notice has to be made 20 days ahead of the time of the hearing. You agree with that?
Yes, sir, I do.
So effectively, you had probably, I'm not counting Christmas or Christmas Eve, but you had a substantial amount of time after that to handle the notice of the hearing, correct?
Could you remind me what day the hearing was?
Sometime in January, 20 days after.
I believe that the hearing was on the 7th.
Yes.
Because, okay, so from the 24th, that would be 7 days, and then that would actually be 14 days, not 20. Is that correct?
Something like that. I'll take your word for it. But in any event, you had 14 days to enter an appearance in the case or ask for a continuance or do something to mitigate the impact of the compulsory pooling hearing.
Madam Chair, I don't understand this line of questioning. The commission has already ruled that Cimarex is the party of record and qualifies as the party of record for the de novo hearing and for the original hearing. So I'm not sure where this line of questioning is going. If we could, get to the point, maybe. Thank you.
Mr. Padilla.
I'll move on, Madam Chair. I think I've made the witness has answered my question. I think that's all I have.
Thank you. Commissioners, do you have questions? Keeping in mind, you need to mute and unmute, please, after each question.
Dr. Ampoma, please go ahead if you like.
Thanks, Commissioner Bloom. I do have a quick question for Mr. Morris. So you talked about you met the landman for Colgate on numerous occasions on other projects. So I want to know, why did you decide not to sought additional information about this particular well?
I'm sorry, what did you?
Okay, let me repeat my question. So why did you not ask um, the landman for Colgate when you met him on several occasions about other projects, about the additional information that you needed, to make a decision on this particular well? Let me mute.
I didn't think that the onus was on us as a proposed party. They were the applicant or operator under those proposals. And like I said, we didn't take it seriously because there was no governing documents or contract area defined. It seemed like a trade inducing proposal, like we had just closed the previous trade.
So is it a normal practice for Ceramax to ignore well proposals from time to time where there is no much follow-up?
I wouldn't say ignore. I would say that you rank them in order of what you would think would be a valid proposal, meaning that are they prepared to actually drill? And one of the first prerequisites to that is to define your contract area in which you're going to drill in and supply a JOA so people can make their election and sign the JOA.
Thank you, Madam Chair. No further questions.
Commissioner Bloom?
Madam Chair, thank you. Mr. Morris, just one question to you, I believe. Did you or anyone else you know at Cimarex receive any emails or other communications from Colgate about this area, other than the one email that we've seen in the documentation here?
No, sir, not to my knowledge.
Thank you, Mr. Morris. Madam Chair, no further questions.
Thanks. I just have one maybe quick question. Can you walk me through the process that Cimarex follows when you're trying to negotiate in good faith efforts? Like, what does that process look like for Cimarex?
In a well proposal focused type of negotiation?
Yeah.
So first we work by supplying the proposal, operating agreement, our contact information. We have a schedule of all of our working interest owners and override owners within the project. And 9 times out of 10, we receive contact from the proposed party, at which point we talk about what their interest is across the contract area and across the proration unit, which can be separate areas. And then we go about talking timing, when are we expected to spud, complete, first produce. And that's kind of the very beginning of it. Once we get to that point, people usually are determining whether they would like to participate or not once they know their interest. At that point, we either talk offers on term assigning their acreage, acquiring their acreage, or having them sign the JOA and participate.
Thank you. Do you consider Colgate's efforts to constitute good faith negotiations?
In this case, I do not.
How many of these have you done, I think, in the past?
How many times have I proposed and then pulled or received non-op proposals?
I'm sorry, have you received non-op proposals?
Just limiting my time to Cimarex, I would say separate proposals, even multi-well projects, probably 2 dozen. I think would be a fair maybe conservative number.
So would you describe how this, I guess, scenario went down for the non-op proposal out of the ordinary?
Yes, it was. And I have to say that, I wasn't in direct communication with Colgate at the time Mr. Kaufman was working the area, but it was out of the ordinary to not have a lot of follow-up to any of the questions, especially given the amount of interest that we had within the proposal.
Okay, thank you. I have no further questions. Mr. Savage, do you have redirect?
I do, Madam Chair. Thank you. Mr. Morris, we can agree under the regulations that Colgate had the regulatory burden to initiate and to affirmatively pursue attempts to reach a voluntary agreement through good faith negotiations.
Yes, sir.
And there seems to be a lot of question, both from Mr. Padilla and others asking questions. Why didn't Cimarex follow up? But wasn't it in fact that Cimarex, or why didn't Cimarex reach out in various instances? But wasn't it in fact Cimarex who initiated the communications to begin with?
Yes, sir. John Kaufman reached out to Mr. Haddock.
And is it true that that was followed basically by 4 months of radio silence leading up to the filing of the application and the hearing?
Yes, sir. That's correct.
And is that not highly unusual for owners of substantial interest and operators dealing with other owners of substantial interest?
Yes, sir. It is highly unusual.
So therefore, when you were meeting with Mr. Haddy on these other projects, other trades, there actually was very good reason for you to believe that this particular well proposal did not go forward.
I mean, honestly, I didn't consider it a valid real proposal because there wasn't a JOA. So I didn't put it even in the realm of trade bait at that point because I didn't think it'd ever get drilled.
And therefore, because you knew that Colgate had the regulatory burden to initiate, to seek and initiate good faith communications and seek a voluntary agreement, it was fair to believe that if it was going to go forward, that Mr. Hadid would bring it up and address it because they needed to get that exhibit, that information into the exhibit for the final pooling.
Yes, sir. That's correct.
And how many well proposals? What percentage of well proposals that you receive actually go to hearing?
I would say it's been on the uptick over the last couple of years, but I'd say about half, maybe. Usually, the proposed party and the proposing party will meet some type of agreement on a trade if we have similar interests. And if we have a minority interest, then we usually don't protest or, do anything.
So there was a good probability that this would not even make it to application, make it to hearing.
Correct. I would not anticipate that a proposal where we had similar interests would have been, taken to this level.
And this particular proposal went into your detailed monitoring system in which you monitor all well proposals. Is that correct?
Yes, sir. That's correct.
And this would have gained higher priority had Colgate satisfied its regulatory burden and reached out to you with an operating agreement.
Yes, sir.
I have no further questions.
Thank you, Mr. Savage. do you have any additional witnesses?
I do, Madam Chair. I'd like to call Mr. Brent McDonald. He's Vice President of Prosperity Bank, and that is the bank trustee for the J.M. Wellborn Trust.
Okay, I moved him to a panelist. Mr. Morris, we're not dismissing you yet, but you're off for now.
Madam Chair, may I just ask how long they're likely to go with this witness?
Mr. Savage?
Yeah, I have about 2.5 pages of questions. Spaced
Mr.
out.
Garland, would you like a break?
Maybe just 5 minutes if I could.
Okay, why don't we come back at 2:45? So that's 9.
Great, thank you very much.
Okay, thanks all.
Sir, this is the court reporter. Would you raise your right hand, please? Except I don't know where he is. Does he have a photograph?
Mr. McDonald, we can't see you. Can we hear you? You're muted if you can hear us.
Yes, can you hear me?
Yep.
I do not have a camera.
Okay. Go ahead, Ms. McFarland.
Thank you. Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. McDonald. This is Darren Savage, attorney for Cimerex in this matter. I want to thank you for your participation in this hearing. I realize it may have been a bit inconvenient, but understanding your interactions with Colgate, I believe, is important to these proceedings. Could you state your name and your position with the bank and your position in this matter?
My name is Brent McDonald. I'm a senior vice president with Prosperity Bank. My role within the trust department of Prosperity is that I manage real estate and oil and gas assets.
Thank you. I plan to ask you a series of questions about your pre-hearing statement and interactions with Colgate. If you don't understand the question or feel like you didn't hear it correctly, do not hesitate to ask me to restate it or rephrase it. We do not want you to answer a question that you feel you didn't fully understand or fully hear. Also, don't feel obligated to state an answer right away if you feel you need to think about it for a moment or two. Mr. McDonald, did you have a copy of Cimerex's pre-hearing statement with the exhibits A through H?
Yes.
Okay, thank you. In Exhibit H, that is Cimerex Colgate's timeline that they used in their January 7th, 2021 hearing. It states, one of the entries regarding the J.M. Wellborn Trust states that Colgate exchanged various emails with the trust from July 2020 to January 2021. Your pre-hearing statement states that you sent 2 emails in July, well, that's part of the period covered by the timeline, one on July 16th and the other on July 30th. And Colgate did not respond to these 2 emails. Is that correct?
That's correct.
Okay. And then you also stated that Colgate finally responded to your email dated August 19th, 2020. Is that correct?
That is correct.
Okay. So therefore, it is fair to say that Colgate was actually unresponsive during the first full month of its timeline in which Colgate claimed that emails were exchanges were going on. Exchanges, I would define as that email, that you sent an email or they sent an email and received a response. But this is actually not correct. They were unresponsive for that first month. Do you agree with that?
Yes.
So it would be fair to say that there was only one email exchange, not various exchanges with Colgate during the first month of the timeline. And this one exchange occurred August 19th.
Yes,
And then after the August 19th exchange, you stated that this was the last email exchange until you received notice of the hearing on December 21st, 2020. Is that correct?
yes,
Okay. So after the first month of unresponsiveness, and then the one email that was prompted after 2 emails that you sent, then for over a month afterwards in Colgate's timeline describing ongoing email exchanges, there were none, including no formal offer to enter into an agreement to acquire the interest. Is that correct?
that is correct.
Okay. And is this what prompted you to go out of your way to and enter a pre-hearing statement in the proceedings?
I entered the statement because I wanted to make sure, we wanted to make sure that it was known that we were not interested in participating in the well.
Okay. And you stated that at the end of your pre-hearing statement that Colgate indicated they would make an offer, and then you say, but to date, an offer has not been received. Is that correct?
That is correct, as of that date of the statement.
And see, there seems to be some ambiguity about what date that is referring to. On the pre-hearing statement, there's a date stamp. It looks like it was received on January 11th, 2021. But when you look in the OCD database, it gives a date of filing as of January 4th, 2021. Can you clarify for us and identify the date you're actually referring to in your statement that indicates by what date you had not yet received the offer?
It would have been December 31st.
Okay, so you had not received an offer on December 31st?
Yes, that's right.
But you did not receive an offer on December 31st. Did you have, so you had no email exchanges except for that one August 19th one all the way up through December 31st. Is that correct?
That's correct.
Okay. So then it looks like at some point you engaged in some email or some kind of communication after December 31st with Colgate, because it looks like that you've finally arrived at some kind of agreement. Is that correct?
We did. I did hear from Mr. Hajik, and we began negotiating. Yes.
And then what date was that those first negotiations or communications take place?
I do not have that date in front of me right now.
It was after December 31st. Is that correct?
That is correct.
Okay. If you could you look at Exhibit H of Cimarex's pre-hearing statement? That is Colgate's timeline. They say on December 31st they provided an offer to purchase the JM Wellborn Trust interest that aligns in price with other accepted offers in the spacing unit. But this, in fact, did not occur on December 31st, right? That it actually occurred after December 31st.
I believe it was after December 31st because we sent the statement in on the 31st.
You sent the statement of the pre-hearing statement in on the 31st. That's correct.
The pre-hearing statement.
Okay.
Yes.
So in all, based on the communications, and that Colgate describes the communications as occurring from all the way from July 2020 to January 2021. It looks like it you agree that looks like it's represents ongoing communications, but in all, you experienced a month of unresponsiveness from Colgate from July 2020 to August 18th, 2020. And then you had one email exchange on August 19th, and that was followed by another full month of unresponsiveness. And then it looks like right before the hearing, sometime after December 31st, sometime in January, you came to an agreement, and that reflects accurately the communications you had with Colgate. Is that correct?
I just found an email dated December 31st from
Okay.
Mr. Haji.
Okay, so
in
that,
which he did state he made an offer at that point.
okay, so that is when the offer occurred, and that was right before the January 7th hearing, about a week before the January 7th hearing. Is that correct?
Yes.
Okay. And do you remember, let's see, excuse me. And based on your testimony at the hearing, both you and counsel for Colgate relied on the fact that an agreement was in place in order to allow the hearing to go forward by affidavit. Is that correct?
I'm not sure I understand the question.
So I direct your attention to Exhibit E in our Cimarex's pre-hearing statement. This is a transcript of the hearing. At least it's an excerpt from that hearing, and a counsel for Colgate. I'm reading this on line 8 on the second page, page 5. So, Mr. Examiner, I believe the parties, being J.M. Wellborn Trust and Colgate, have reached an agreement that, assuming that's what drew the division to set it for a status conference, Colgate's prepared to present this matter by affidavit this morning. So would you agree that the agreement that you reached is what you and counsel for Colgate relied on to allow the hearing to proceed by affidavit?
I'm reading, yeah. I'm reading the.
Okay, yeah, take your time. In other words, if you had not reached an agreement, it sounds to me like, based on that testimony, that it would not be the case could not have gone forward by affidavit. Do you agree with that?
I'm not sure how the procedure would work on that. I was just saying within that statement that we had arrived at an agreement to the basic terms of the assignment, and we were reviewing the assignment,
Okay.
the form that they sent us.
Yeah, thank you for that clarification. Do you realize that the interest of the J.M. Wellborn Trust was effectively pooled by the division's pooling order because Colgate did not remove the trust from the list of uncommitted owners after stating that the agreement had been reached?
No, sir.
Okay. Did Colgate explain to you in any way the consequences of pooling under an order versus an assignment?
No, sir.
Okay. Did Colgate live up to its agreement?
We have not finalized an agreement with Colgate.
So they have not acquired the interest, and you have not been able to assign it to Colgate.
That's right.
And is that because of your reservations, or is it because of their reservations?
We finished negotiations in February of 2021, and I sent a signed form to Mr. Hajig. We do that by email so that we can request the payment, and I did not get a response from him until June. And at that point, I knew there was ongoing issues with the commission, and I had reservations at that point.
So it was Colgate's failure to acquire that after they after you guys reached an agreement. Is that correct? Is that a fair statement?
In June, Mr. Hajic said they were ready to proceed at that time, but I did not respond to that.
Okay. All right, Mr. McDonald, I thank you for your time on this and your clarification. Madam Chair, I ask that Cimerex's exhibits D and E be admitted into the record. And I have no further questions for Mr. McDonald at this time.
Any objections from the parties of entering, I think you said exhibits D and E?
That is correct. Okay. That's Mr. McDonald's pre-hearing statement and then the excerpt from the transcript from the hearing.
Mr. Padilla or Rankin, any objections?
No objections from Colgate.
No objections.
Commissioners, any questions about exhibits D and E before they are entered into the record?
No objections, Madam Chair.
No objections, Madam Chair.
Thank you. Cimerex exhibits D and E are now entered into the record. Mr. Padilla, do you have questions for Mr. McDonald?
Yes, I do. Mr. McDonald, are you saying you never finalized the agreement between yourself?
There was never a finalized agreement with Colgate.
Okay. And in your pre-hearing statement, you say that you had 2 emails. Is that right? Am I reading that correctly?
Yes.
Okay, I'm looking at a string of emails between you and Mr. Hajic. On July 16th, you sent an email acknowledging receipt of proposal, correct?
That's correct.
Then on July 30th, you sent a follow-up email. And you're saying essentially just following up on this request. Thank you. Correct?
Yes.
Then on August 19th, you sent the same email essentially saying you're following up. Right?
Yes, sir.
Then on the same day, Mr. Hajic sent you an email sending his apologies for not responding quicker, correct?
I do not remember the content of his email, but I did receive a response from him, yes.
Then on the same day, August 19th, you indicated in an email that you would be interested in an assignment of the trust interests, and you desire not to participate. Is that right?
Yes, sir.
Then we jump to December 22nd, and you're following up on the proposal again. Right?
December 22nd, yes.
Okay. Then on December 31st, Mr. Hajic told you he could offer $3,100 for the trust interest in the well. And he further says, please let me know if there's something that you are agreeable to. Correct?
Yes, sir.
And on January 4th, you said you wanted $10,000 for the trust interests, right?
Yes, sir.
And January 4th, same day, Mr. Hatchett told you that was significantly higher than actual market pricing for this area. And he said, I cannot accept your counter. You have that.
Yes.
Same day, on January 4th, you indicated that you want to come to an agreement and you're offering a 20% discount. I'm not going to read the entire email, but that's essentially what your economics are saying.
The engineer that we use to value the asset recommended a 20% discount.
Then on January 5th, Mr. Hadjic sent you another email indicating that he understands your restrictions. And he's saying he can't get approval to deviate from actual or ground transactions that they've seen in the area. Then there's a couple more on January 5th, back and forth. And then January 7th, Mr. Hadjic tells you, he sent you another email asking, he says, in effect, to get a check cut, I will need a scan of the signed deed and a W-9. And he asks you further, are you going to be agreeable to the pooling hearing going forward today since we have reached an agreement here? And then on January 7th, you said, thank you for forwarding the form. The form is under review. Well, you go on, have more email exchanges on January 11th, January 19th, January 27th, and February 1st, February 5th. So even after the hearing, Colgate was trying to get agreement, right?
Yes, sir.
Is it fair to say that you just wouldn't come to an agreement, or what? I don't understand why you didn't go forward with this transaction.
We were negotiating the terms on the form as part of that.
One of the forms indicates for Mr. Hadjic that if you have a lesser interest in the prospect, then you would be proportionally reduced, correct?
He wanted to, yes, that needed to be included, the proportionate reduction language.
Okay, but all this time, I mean, that's contrary to what you're saying in your pre-hearing statement, is that you didn't have any discussions at all, and you only had essentially 2 emails. That's incorrect, isn't it?
As of the date that I wrote the pre-hearing statement, all we had was 2.
Well, afterwards, why didn't you withdraw your pre-hearing statement or amend it?
I didn't know I was supposed to withdraw it.
But it's inaccurate, correct?
No, sir.
I'm going to object to that, Madam Chair, it is, I feel like they're badgering a witness that made a good faith effort to do an accurate pre-hearing statement. The pre-hearing statement is true in context. And I believe that, Mr. McDonald is an experienced trustee, but he doesn't have experience specifically with the OCD. And I believe that Mr. Padilla is trying to intimidate him a little bit.
Mr. Padilla, I think you've kind of asked these questions and the witness has answered. So once he provides an answer, just move on to the next question, please.
All right. I don't have any further questions.
Do the commissioners have questions for the witness?
No, Madam Chair.
Madam Chair, no, I believe I do not.
I do not either. Mr. Savage, do you have any redirect for the witness?
I have some quick redirect on this, if you don't mind. Mr. McDonald, in Colgate's communication timeline, they show that you had email exchanges from July 2020 through January 21st. Your pre-hearing statement sounds, based on the iteration that Mr. Padilla provided prior to the hearing, it sounds right on point, very accurate. 2 emails spaced between, over the course of a month, were sent. Colgate was unresponsive. Is that correct?
That's correct.
August 19th is the only email that was responded to. Is that correct?
That's correct.
And then Mr. Padilla brings up an email from you, which you did not mention in the pre-hearing statement. That was December 22nd that you sent. And you received no response from that email, correct? Or immediate response?
That the response was December 31st.
December 31st. So that's over a week to respond to that. And that happens to correspond with the approaching hearing. And that's within January 7th. So that's within the week. Would it be fair to say that based on what your experience with Colgate, that you had a pre-hearing statement in, they were concerned about going forward with the hearing?
Please restate.
Would you agree that the Colgate was concerned about being able to go forward with the hearing with your pre-hearing statement in place?
I don't know.
Okay, but they did reach an agreement, and it looks like in the transcript that counsel for Colgate stated that because of the agreement, they were able to go forward by affidavit. Is that correct, based on your review of the transcript?
On that transcript?
Yes, I'm sorry. Let me
referring to is on line 8.
That's exhibit. Let me find it here. Exhibit E. And that is line 8. And it's at the top is page 5, and it's exhibit E in the pre-hearing statement. Do you agree that the counsel for Colgate stated, I believe the parties, being J.M. Wellborn Trust and Colgate, have reached an agreement? And
I see that. Yes.
Yes. And as a result, they were able to go forward by affidavit.
Yes, sir.
Okay. Thank you for your time, Mr. McDonald, and I have no further questions.
Thank you, Mr. Savage. Do you have any additional witnesses?
Madam Chair, that looks like it concludes my witnesses.
Thank you. Mr. Padilla, you have witnesses?
I have one witness to be sworn.
Would you like to go ahead and call your witness?
I call Mark Hadrick.
Who is it?
Mark Hadrick.
Oh, okay. I think he's already a panelist.
Hear me?
Yes.
May I swear him without a picture, without a photograph? May I just,
I see him.
okay, so Mr. Hadrick, would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yeah.
Thank you.
Mr. Hadrick, please state your name.
Paddock. Colgate Energy.
How do you spell your
Sorry,
last name?
I'm sorry, I can't understand him at all.
Move closer here. Mark Haddock with Colgate Energy. Haddik is the spelling of his last name.
Mr. Hadrick, you're a landman for Colgate operating, is that right?
Correct.
How long I know that you've been qualified as an expert landman before the division. But would you tell the commission briefly what your work experience is and where you received your education as a petroleum landman?
I don't have a petroleum layman degree, but I have a law degree from South Texas in Houston. I've been a landman for over a decade. I've been previously with Anadarko, and I've been at Colgate for about 4 years. The last 2 or 3 working on New Mexico properties.
And you've been qualified as an expert landman before the Oil Conservation Division, correct?
Yes, I have.
Yes.
Yes, I have.
Madam Chair, I've been trying to, I think I need your permission to share documents.
Yep, I can do that. Give me a second. Okay, you should be able to now.
Ah, there it is. Mr. Hadrick, Exhibit 1 is your portion of the January 7, 2021 hearing. That was offered at that hearing for the Meridian 3 Federal State Com 131H well. I want to take you to your affidavit, and I want you to look at paragraph 4. You see that?
I'm not seeing any shared screen. But...
I don't see your shared screen, Mr. Padilla.
Maybe I need to tell it to share.
I think so.
Mr. Padilla, do you see the share button beside the video button? Should work.
It's not the right one. There, can you see it now?
Yeah, it's kind of tiny. Everyone, you can, there are the buttons on the left-hand side of the screen where you can make it bigger or smaller, the zoom out, zoom in. So,
Let me expand this. Is that better?
yeah, that's better. Thank you.
Okay. Can you see it now, Mr. Hadjic?
Yes.
Okay. You state in there in your affidavit, prior to filing its application, Colgate made a good faith effort to obtain voluntary joinder of the working interest owners in the proposed well. First question I have is Cimarex a working interest owner for this proposal?
Yes.
Now, there's been a lot of discussion about whether one email from you to Mr. Kaufman is sufficient or is a lack of good faith and doesn't meet the requirements of the regulations and the statute for compulsory pooling. I want you to tell the commission why you made this statement and why you say that you made a good faith effort to obtain voluntary joinder with Cimarex.
With Cimarex, I mean, I had no indication from them that my last communication was insufficient, and with the larger, more sophisticated operators, it's not uncommon to get some questions and then you don't hear from them again, especially if they have and so I don't know their internal review process, what their decision points are on these. I mean, for example, I answered questions for Concho, and then they were satisfied to let this case go to hearing via affidavit and be force pulled. So I assumed that was the same case here since I hadn't heard from them. There was a number of small owners, like Mr. McDonald, who had reached out that I needed, that the follow-up was in my camp, and we made sure to get those responded to. And there were a couple of other small parties in here that we had acquired over the months leading up to or right after the hearing.
Do you typically send a JOA on your well proposals? Colgate.
It depends. We will always provide it upon request. I mean, that's an absolute must.
So sometimes you send it, sometimes you don't. Is that right? Is that what you're saying?
We are making it a more common practice to send them. There was, probably a period of time where we did not. We just provided it upon request.
What is the standard practice in your experience in the industry as far as submitting JOA with well proposal?
It's all over it's any variation. I mean, I've had proposals from EOG that don't include a JOA and include the disclaimer that one will be provided upon request, and then I have I've also received proposals that do have a JOA. I would say it's a mixed bag.
You heard Mr. Morris's testimony, correct? Did you hear Mr. Morris's testimony?
Yes.
Okay. Was talking about spacing unit and a contract area. He said that they were two different things. Do you agree?
Yes.
Tell us about what is a contract area in a JOA?
Contract area in a JOA is literally whatever you want it to be and the parties are agreeable to. It has nothing to do with the OCD spacing unit, which is outlined in the proposals. You know, and in this case, we weren't proposing anything beyond the spacing unit of the well. So there wasn't a contract area to discuss that exceeded what was already in the letter.
When you are sent a proposal to drill a well, what's your procedure?
It's on the nature of the acreage. If we're agreeable to being non-op, then we usually sign a JOA or let it go straight to hearing. If it's something that we're opposed to and would want to compete for operatorship, then that goes into a different bucket. And all of those, we have land coordinators who put it into our tracking system, and then usually trigger some sort of trade or other discussions where we reach out to that proposing operator to ensure our rights don't get compromised.
Well, in this case, the issue is that you did not reach out and that one email is not enough. What do you have to say to that?
I felt that I had answered the question and I didn't get any further questions. So I'm not aware of their inner workings, and at the time I wasn't aware that they had discounted this as a not real proposal. And
You heard the testimony of Mr. Morris and Mr. Kaufman saying that they didn't think you were serious. What is your response to that?
Multiple rigs operating in the area. That's their own prerogative to not take that into consideration. That this could be a real proposal. We internally do not discount or fail to evaluate proposals based on some internal ranking. If it's on our acreage, we are going to do what we need to do to preserve our rights or resolve the situation.
And that's when you're the target of a well proposal or a compulsory pooling application, isn't that right? I guess you didn't hear my question. If you're the target of a well proposal or a pooling application, that doesn't have a JOA attached to it, do you disregard it?
No, if it meets the basic OCD requirements that could result in a hearing being filed, then no, we would not disregard it.
Well, Cimarex is saying that the burden was on you to follow up. What do you have to say to that argument?
Say that I answered their question, and if they had further questions, I never received those. It's not uncommon to for working interest owners to go radio silent on you until hearing notices go out. And then at that point, they do realize that you're serious. And I still didn't get a response. I just assumed that they were satisfied with proceeding to hearing.
So you think it's a two-way street, or what do you have to say about negotiations back and forth?
I would assume it's a two-way street because I don't, or I believe it's a two-way street because I don't know what they need. I don't know if they have, the working interest owner has accurate, you know, I don't know what their questions can be all the time. I mean, it's a wild array of questions you get from the basic, how do I even own this, all the way up to what is your frac design? And, you know, I need those parties to ask those questions once they've, you know, had our initial contact.
You were also doing trade negotiations on other acreage, correct?
Correct, but it was with Riley, who wasn't working this proposal at the time. At the time of I was communicating, I was under the impression Mr. Kaufman was handling those wells, or the wells in question.
Well, Mr. Riley says that you should have asked him or somehow contacted him about this proposal. Do you normally change from one landman to the other if that occurs?
No, not unless there's a reason to cross it over. And as he already indicated, that trade was already approved and teed up. There wasn't any modification to that at that point, so I didn't see any reason to talk to him about it.
And that was another trade.
That was completely unrelated matters.
Okay.
Yes.
Let me take you to the next. Well, before I move from that, let me just direct your attention to the same exhibit as ours. It's the email that was prior already introduced in here. Including the timeline of your discussions with the working interest owners, but our exhibit 2 is that email exchange from you and Mr. Kaufman. You have it there in front of you.
I'm generally aware of it. I could pull it up if I need to. Okay.
First of all, let's look at your email. It says at the top of the page, and you indicate that your operated strip is north half, and I assume that's for sections 2 and 3, right?
Yes.
You say due to our consolidated operational efficiencies, we would be happy to talk some options for the offsetting acreage in order to fully maximize the development of the area. What did you get back?
Didn't get any follow-up questions or proposals or thoughts from Rex.
You didn't get anything back, right? Did you hear my question?
Correct, I did not.
Okay. Did you get anything back from Mr. Kaufman?
No.
Do you know what acreage they would have in the north half for a JOA contract area?
I'm sure we have information on it, but our acreage didn't. We weren't proposing a something larger than our spacing unit, and hence why I said if they wanted to work on something, I would be happy to discuss it.
Did you get anything back on the north half JOA?
No.
Is that no?
No.
Okay. So when you're dealing with somebody like Cimarex, is there a different approach than just simply, or say, for example, when you're dealing with Prosperity Bank with Mr. McDonald?
Yes, I would. Company like Cimarex, who has extensive experience with the, OCD matters, I'm going to, assume they understand repercussions and for actions and timeline. They're going to have an in-depth understanding of the necessary timelines versus, somebody like Mr. McDonald, who has very small interest in, doesn't, needs much more follow-up communication to help, to effectuate their rights.
In your opinion, when you get a well proposal that's not accompanied by a JOA, do you rank it as being a poor proposal or give it no rank?
No, it's treated, they're all treated the same. I mean, I would assume that that operator could file for hearing on any proposal we get that, 30 days later is the baseline assumption.
Exhibit 3 is that the application to reopen this case. In there, I highlighted a portion where Cimarex says that COVID, Christmas, and all that sort of thing somehow interrupted the compulsory pooling process. Did you, were you aware of any suspensions of compulsory pooling applications because of COVID or because of Christmas?
We filed accordance with OCD schedule. That's all.
Did you purposely time the notice of hearing to be received by Cimerex on Christmas Eve?
No, I mean, we would have put them in the mail 20 days out. I mean, I don't set the dates for when, this is the OCD calendar, so.
And it's your opinion that paragraph 4 is accurate in terms of good faith when it comes to Cimerex. Is that correct?
Yeah, that's my belief that, a lack of response was an indication that they were fine with us moving forward with our hearing.
Okay. We offer exhibits 1, 2, and 3. That's all I have, Madam Chair.
Any
Mr. Padilla,
objections to entering?
Madam Chair, I just want to clarify, are these, it looks like these are lettered exhibits, unless I've got the wrong document, Mr. Padilla.
No, we have exhibits 1, 2, and 3.
Oh, okay. I think I was confused by the sub numbering. Okay. Thank you, Mr. Padilla. My apologies.
Mr. Savage and Mr. Rankin, any objections to entering exhibits 1, 2, and 3?
No objection?
No objection. Thank you.
Commissioners, any questions or objections?
No objections, Madam Chair.
No objection, Madam Chair.
Okay, Colgate exhibits 1, 2, and 3 are entered into the record. Mr. Savage, do you have questions for the witness?
I do, Madam Chair. Thank you. Mr. Hadi, good morning, good afternoon. Thank you for your testimony today. I want to ask you a number of follow-up questions for clarification. If you do not understand the question or feel like you didn't hear it correctly, please do not hesitate to ask me to repeat it. If a question lends itself towards a yes or no answer, if you would, to the best of your ability, it would be helpful to answer that in that manner. But of course, you would have opportunity to provide any additional explanation. I want to go real quickly just to talk about the notice issue that Mr. Padilla brought up. Is it true that there was the OCD was under COVID emergency conditions during that time?
I'm not sure what you're talking about.
Did the OCD not issue emergency contingencies and emergency plan to handle and deal with COVID during that time period?
I'm not aware of any modifications to the notice periods.
Okay, because if I remember right, the OCD announced that there may be opportunity for exceptions.
Mr. Savage, questions, please.
Yes. Are you aware that the OCD provided certain exceptions during that time if they invoked COVID emergency concerns or issues?
Like I said, I'm still not aware of what you're talking about. I don't. Was there an?
Madam Chair, I believe we can take judicial notice that we were under COVID emergency conditions at that particular time. And it was up to the discretion of the OCD or OCC to grant those any exceptions under those based on justification. Can we agree to that?
Mr. Moander, what's the procedure for that?
Mr. Savage, could you repeat that again? There was a lot in that sentence. I want to make sure I got everything.
Yes, Mr. Moander. It looks to me like it was clear that the OCD and OCC were under COVID emergency conditions. I believe that there is still a notice on the OCD and OCC website that give that information. I was wondering if it's possible to take judicial notice that during that time period, we were operating under a COVID emergency health conditions.
Madam Chair, I think my concern with this is that I'm not sure I'd call it emergency COVID conditions, but I think given the fact that it is absolutely no secret that we've been under the governor's health order, and that OCC and OCD were governed and by that order, that the commission could take judicial notice of that. I'm not sure that I would not recommend that it be described as COVID emergency anything other than that there was a COVID health order from the governor that impacted some of the functions of the commission, in particular the in-person meetings. But I think that's probably the extent of it at this point. Now, as an alternative, if there's a version of the health order that was in place at the time, or has remained in place, that could also be judicially noticed and put into the record.
Fine, taking notice of the public health order. I mean, we did continue to have hearings. They were just electronically as opposed to in person. So is there anything we need to do for that, Mr. Mohinder?
You're allowed to state essentially that you are taking judicial notice of that, and what it is effectively is it's recognizing and establishing a fact.
Okay.
I recommend that you permit Mr. Padilla and Mr. Rankin, if they have their response to this as well, before you proceed. But yeah, that you would essentially acknowledge that health order was in effect at the time of what's being discussed here, and I think that's correct, and that fact is now established. Again, I'd let the other parties comment on this if they wish.
Any comments, Mr. Padilla?
Madam Chair, and the commission, there's no question that there were emergency orders. Continuances were granted, but the process for hearings or notice were not changed. If that's where Mr. Savage is going with that, then I disagree that the emergency orders suspended or otherwise amended notice requirements for hearings. Sure, there were an emergency orders, and we didn't have any hearings, or still don't have any hearings that are in-phase hearings, or so those are continuing. So I don't have any problem with mask mandates or the other policies that about distancing and that kind of thing. But to the extent that notice requirements were amended, if that's where Mr. Savage is going, then I don't think the emergency orders went that far.
Madam Chair, I would also agree with Mr. Padilla's assessment of that the health orders concerned, for purposes of OCD and OCC, those health orders, like essentially every other entity in the state, were prohibited from meeting in person. But it is also true, as Mr. Padilla said, that health order did not amend or otherwise alter any of the procedures or processes for hearings for OCD or OCC. See, here's the problem with this: is we're now starting to migrate further and further away from judicial notice, Madam Chair, because we're getting really, really specific here, which does cause me a little concern. But I think if you found there was a health order in place at the relevant time, that it, for all intents and purposes, prohibited in-person meetings, hearings, etc. And I think you could also find that that OCC, and in particular OCC and OCD procedures for hearings were not altered outside that limitation on in-person meetings.
Madam Chair, I'm going to make everybody happy here, and I'm going to withdraw the request.
Well, Mr. Savage, I want to give.
It was an effort on my part to attempt to address contingencies and considerations under COVID conditions. But I think I'm going to move on because I think there's more important issues in here that we need to address, and it's getting towards 5 o'clock.
Mr. Savage, I appreciate that. However, and I don't intend to speak for the commission as a whole here, but I suspect that all of the commissioners are probably acutely aware, and especially Madam Chair, of the particulars of the COVID health orders and so on. And I will also make sure they are reminded of that if that is an issue.
Thank you. All right, Mr. Haddick, your communication timeline, you have a copy of that. That would be Exhibit H in my pre-hearing statement and Cimarex's pre-hearing statement. And I think it's also Exhibit B3 and Exhibit 1. Which you should have a copy of, because that is your exhibit. Is it there's an entry in which you point out ongoing communications with Cimarex, and you have a time frame from August 2020 to January 2021. Is that correct? And Cimarex is included in the in that list described as responded to various email questions. Is that correct?
Yes, because that's what I had done, and then there hadn't been, it was just kind of open at that point. I hadn't received a response, so that was the intention of that statement.
But as we know, based on looking at the single email exchange, it'd be accurate to say that there was just this one email exchange. No other emails represents in that time frame that you provide, August to January. Is that correct?
Yes, I already said that. Correct.
Yes. All right. Thank you.
Mr. Haddick, I'm not getting your answers very often. Also, I think maybe when it's just a yes or a no, they just don't show up. So you may have to move closer to the mic just for single word answers.
Okay.
And just to note the obvious, it was Cimarex, not Colgate, who initiated the communication. Is that correct?
Just pretty standard procedure, though. I initiated the conversation with the well proposal.
Okay. And in your response to Cimarex, in your communication timeline, you described that that you addressed the decisions to participate. It looks like affirmative decisions regarding their participation or the willingness to sell. Is that correct in your description of your entry for that August 2020 to January 2021 entry that includes Cimarex?
So it says yes.
And in your response to Cimarex, in the email response, did you ask or inquire about a decision regarding Cimarex participation or willingness to sell as you describe in your timeline?
You've seen the email. That's part of the record.
I'm sorry, I didn't understand that.
I said no. The email was just asking what they wanted to do, or we were open to discussion.
Okay. In fact, is it not true that Cimarex referenced a question regarding a potential JOA, which is part of a discussion to reach an agreement mentioning a JOA? Would you agree with that?
Correct, but we weren't even proposing wells and what they were talking about, so I really didn't understand their question and why we're question it, period.
It is the only communication between Colgate and Cimerex, is that correct? Is the sole communication between Colgate and Cimerex?
I said yes. I'm sorry, didn't hear.
All right, I'm sorry. I had a difficulty hearing that. Thank you. In your communication timeline, in another entry, you gave a specific month, December 2020, for an entry of a singular communication. That's December 2020, and you described Conoco as agreeing to participate. Is that correct?
Correct.
Yet for Cimerex, with whom you had only one communication, you grouped the one email exchange with Cimerex that occurred only in August 2020 with the other email exchanges that shows to the OCD ongoing communications from July 2020 to January 2021. Is that correct?
I'm sorry, maybe I'm getting tired, but I just cannot understand you sometimes, Mr. Savage.
Okay, let me repeat that.
I know you're reading it, and that's part of the problem. It doesn't sound like normal tone. So can you read that one again, please?
Yes, yeah, Mr. Haddy, for Cimerex, with whom you also only had one communication, you grouped that one email exchange with Cimerex that occurred only in August 2020 with other email exchanges that shows to the OCD ongoing communications from July 2020 to January 2021. Is that correct? You did group that one email within that entry that shows or implies ongoing communications over the course.
I don't know that it would imply on that. That's not my interpretation of that. That implies ongoing communication. It says responded to various email questions from list off a number of parties. I guess you could say a best case scenario, you could say it's vague, but I wasn't trying to imply that.
Best case scenario, possibly it's ambiguous. Is that correct? Sure. Do you think the accurate representation to the OCD of your communication with Cimerex would have been to separate out the email exchange as occurring in August 2020, as you did with Conoco?
Conoco's had been ongoing as well. It wasn't a one-off situation. So.
Well, there was something important obviously about that December 2020 entry. Is that correct?
They had responded and to our proposals, and we had and responded to my communication, and we resulted in them saying they would plan to participate rather than sell. Or I believe it's sell. I don't remember, but I don't have that communication in front of me.
Well, is it fair to say, can you see how grouping your one communication with Cimerex within a time frame of ongoing communications from July 2020 to January 2021 would be misleading to the OCD?
Wouldn't say it's misleading based on the way it's worded, but I could see how I agree with that it could be ambiguous.
Okay. You've been involved in numerous poolings, it looks like, based on what I see on the docket. Are you generally familiar with the customary process of filing for hearing and proceeding to hearing pursuant to the rules of the OCD and OCC in general?
Yes.
Are you familiar with the rule that an applicant must show, quote, evidence of attempts the applicant made to gain voluntary agreement, including but not limited to copies of relevant correspondence? I direct you to paragraph 8 of your exhibit 3. This is rule 1915-412A B6. What's
your question?
Are you familiar with this regulatory requirement for an applicant under a pooling?
Yes.
Can you see that language? Do you have that exhibit? It's your exhibit 3, paragraph 8, if you want to see the.
Just for y'all's record, this is Jagon. It's been a pretty long day. It's 5 o'clock in Texas, and some of us have childcare restrictions, or obligations. So I'm just not trying to not answer your question, but
Okay.
What are your timing limitations?
we have 15 minutes.
Okay, my guess is that this is probably, let's take a quick pause and talk about timing. Okay, so I mean, it's already 4 o'clock here. We need to finish Mr. Savage's questions, do commission questions, then Mr. Padilla's redirect. I do not think we're going to get that done in 15 minutes. We also, then I think, Mr. Padilla, this is your only witness, is that correct?
That's correct.
Okay, I think there's potential the commissioners might want to recall witnesses if they have further questions. There is closing and all of those pieces. None of that, and then deliberations. None of that, I believe, is going to get done before 5 today. I also think that the way that these hearings were scheduled, they were scheduled back to back. There was the one we're doing in February, and then the one we have on the March docket, depending on how this one goes. So we need to have this one concluded rather judiciously, like move it along. But I don't think we're going to finish it today. I am somewhat limited on additional timing this week and next week. This week, really the only availability that I could have, I could probably move things around and do 9 to 12:30 on Thursday to continue this, or like 11:30 to 3 on Friday. It sounds like we're going to need to schedule a continuance date to finish this up, because I do not think it's finishing today.
And Madam
So-
Chair,
Thursday and Friday.
Sorry, what?
I'm out Thursday and Friday, Madam Chair.
Okay, I'm
I'm
out
sorry.
Monday, Tuesday next.
I'm sorry, I can't hear anybody. I can hear Madam Chair, but I can't hear anybody else.
I think Commissioner Bloom said he's out Thursday, Friday this week. And you can probably always hear me because I'm exceptionally loud. Okay, well, that pushes it into next week. I am out Monday, Tuesday. I could do from like, I'm open from, I could probably move things and do things on Wednesday morning, or from like 9 to 2-ish on Thursday, or Friday morning. That's about where I am. Commissioners, do any of those, and Mr. Moandar, do any of those times work for you? And then we can work on the parties.
Madam Chair, I have a court hearing on Wednesday the 2nd or not a court, well, not a hearing, but I've got an obligation related to some litigation. I probably wouldn't be available till 10:30 on the 2nd, and I can make myself available on the 3rd or the 4th.
Okay, so let's look at the 3rd or the 4th. On the 3rd, I could do 9 to almost 3, and Friday, I've got most of Friday morning. Will that work for the other commissioners?
Madam Chair, so Thursday, I do have a class, so I cannot, but I can do Friday anytime.
Okay, what if we do like 8:30 to, I could do probably up until 1 o'clock that day,
What date is that, Madam Chair?
the 4th.
A Friday.
I'm open then.
Mr. Savage?
That would work for me. Thursday, we have the OCD hearings, but
Yeah, So let's try, avoiding Thursday would be good. Will that work for the witnesses? Can we make it work for witnesses?
Not really. I'm not in it. Kind of travel commitment out of the office on personal matter on Friday.
The 4th?
Yes.
Okay. First day is OCD, I'm assuming, and you've got a class, Dr. Impoma. I mean, that means we're pushing it into the next week of the 7th, which is fine. We would need to continue probably the next case off of the 10th docket, or we could continue this on the 10th at that point because we're already that week.
You know, Madam Chair, that might make sense to put this on essentially, well, what do we know, or do we have any idea? I haven't looked at obviously the case that we're going to probably hear on the 10th yet, because we got to get through today. So I don't know how long. I mean, we could face the same problem again on the 10th. So continuing that case that's currently set for the 10th and replacing it with this one is probably our best bet. Alternatively, if there's any openings that week, I mean, I can tell you that I'm available all day on the 8th and 9th and in the morning only on the 11th.
I could do the 7th or the 9th. I cannot do the 8th or the 11th.
So how about the 9th? How's that look?
Well, I'm kind of wondering what's the point of doing it if we're having a hearing the next day anyway? Why don't we just continue the case that's on the 10th and have it all on the 10th?
Okay.
Let me see if there's anything already on the March docket other than this. We also have another, which could continue. There's a de novo case for compulsory pooling application of Spur Energy that day.
Madam Chair,
Yes.
I may offer some relief to the commission's docket.
Oh.
Yeah, I'm all ears now, Mr.
Yeah,
Rankin.
we're listening, Mr. Rankin.
Well, we will be filing a unopposed motion to continue that Spur case, so that docket should have some additional flexibility.
Hallelujah. Thank you, Mr. Rankin.
So since we're already in that week, let's continue this, the 10th, and continue the case that is currently on that docket to the next commission hearing, assuming we need it.
Why don't we check with Mr. Hajdik see if he's available, just to make sure.
Oh.
Yeah, because it is a little different here where we can't just strong arm the witness in. Mr. Hajdik, do you know your availability on the 10th?
Say the 10th, I don't see anything on my calendar, so I should be good.
Perfect. Thank you.
Mr. Savage, how about your witnesses? I think there's a chance we might recall some of them.
Okay, are they still online? I believe they are. Mr. Kaufman?
Yeah, I'll make myself available anytime.
Okay.
Mr. Morris, I mean. It's gonna be a long day.
Yeah, I'm available.
I believe we should be through with Mr. McDonald, I would think. Is that correct, Madam Chair?
I believe so. Okay.
I do have one comment. It looks like, there are a number of wells in those sections for the Crest well for Cimarex's Crest well, which is competing applications. It looks like we ran across an existing unit that overlaps in one quarter section, and I think we're going to have to do an amended application for that. So, this may work out that, we have some additional time but we'll need some time to do that application and do the notice for that. Just to let you know, give you a heads up on that.
Okay.
Yeah, thank you.
Thank you, Mr. Savage.
Okay, so at this point, do we
So, Madam Chair.
Continue questioning of the witness until the 10th.
I think that's probably the way to go, because given what and I hope I pronounced it correctly, because I feel like I'm not. Mr. Hosdick's schedule, he's going to be leaving in 5 minutes, or needs to be leaving. So I think at this point, if you wanted to state on the record under Rule 19-15-4-15 NMAC, that this matter will be continued to March 10th at 9 a.m. to finish the evidentiary record and then proceed to deliberation, you would be okay in doing so.
Yes. Yes, let's do that.
Okay, so that's so ordered, Madam Chair.
That is so ordered.
Excellent. And with that, I would recommend we go ahead and proceed through the remainder of the agenda and close out the hearing upon completion of the agenda.
Okay. The remainder of the agenda is other business, so if the witnesses need to drop, you can drop.
They don't need to stay.
Okay. Let's see, agenda item number 6, since we are continuing agenda item number 5 onto the regularly scheduled March 10th docket. Mr. Moander, do you have any updates on pending litigation?
I do, to the extent that it's case A-1-CA-39578, which I've updated the commission several times about. I checked the docket. I haven't been served any additional pleadings or notices, and so we are still awaiting a ruling from the Court of Appeals on that case.
Thank you. Any other business before the commission today?
Madam Chair, it sounds like on our March meeting here, really the focus is going to be finishing up Cimerex and Colgate. But on the 10th, I'd let you know if we need more time, or if you see any other needs for time. I'd be available that Friday morning, the 11th, and I'm going to be out the next 2 weeks. It's like my first vacation in 3 years, so I will not be available at all. I'm not taking my iPhone. I'm going.
How dare you, Commissioner?
Around for 2 weeks.
I am really impressed and super jealous. So I think basically the only thing we're going to end up having to finalize is this case on the 10th, which I do believe we can do with a full day on the 10th as necessary, if it even takes that much time.
I think that's a correct assessment, Madam Chair.
And then you can go off on your vacation and forget all about us. Great.
Monday the 28th.
All right. The next meeting is on March 10th, 2022. And with that, it is 4:13 on Tuesday, February 22nd, and we will close for the day. Thank you, everybody.
Before you close, I'm sorry to do this, but right at the beginning, when you were reading on the agenda, about the agenda and the minutes, I know you meant 2022. You actually said 2020.
Oh, geez.
Good catch.
Can everybody agree that I may change that to 2020? I'm just being it's court reporter brain. If both commissioners agree, I can change that to be 2022 in those 2 instances.
Very good. Thank you. Good catch.
Agreed.
All right.
Thank you.
I guess we can't go back 2 years. Yeah. I don't want to go back 2 years. So thank you. Good catch. All right. Have a great rest of the day, everybody.
Bye, everyone.
Bye.
Bye-bye.